It's a huge issue.
I understand that.
We're live, I believe.
We're
It
live.
should have,
Okay. Are there other issues regarding S3? I think there's been some confusion about the amendment and when the amendment was posted last night. S3 as a bill's been out for a long time, but the amendment wasn't posted till last night. So I wanted to make that clear. Eric had asked me when to post it, and we had a correction on it. So when the Department of Mental Health said they hadn't seen it until last night, they hadn't seen the amendment. They've seen S3. They've known that's been around for a long time. And what I was apologizing to was that they weren't part of the discussion. Just so it's clear to everybody. They did not see the amendment until last night, I guess. Or whenever. And I apologize for them not having seen it beforehand. They weren't involved with the writing. That was done mainly by David Scher and Eric Mathage and DJ Donovan and James Pepper. So David, maybe you could comment a little on that. And did you discuss it at all with the Department of Health? I mean, Department of Mental Health?
Senator, for the record, David Scher, the Attorney General's office. There were some brief internal discussions with, among the attorneys. Attorney General's office obviously also has Assistant Attorney General representing the department, but there were not extensive discussions about the broader policy issues.
Right. All right. Just so it's clear, we didn't, nobody was, that was my fault. I should have asked that they have a chance to look at it. But it is what it is, and this isn't abnormal, by the way. We're amending bills all the time, and to ask to, be informed all the time we're doing amendments is not as easy as it might sound, especially when you have other groups doing the drafting. So Eric, terrific job. Are there other committee questions or other people you want to hear from on the amendment? We have Judge Grierson tomorrow morning and Matt Valerio. And then we'll do maybe some more markup. I don't know. Anybody else you want to hear from tomorrow? And then we'll hear from Mental Health and Vermont Care Partners on writing. Anybody else we need to hear from? Okay. Well, I guess we need to hear from Joint Fiscal too, or at least Eric, who's going to work with Stephanie for the language.
Right. I'll send her an email after the meeting.
Yeah, at the very least, we want to make sure that the people who are in the forensic working group are going to get paid who are not state employees or not. There's no legislators in it. And then we also, Jack's going to look for and see if anybody has any idea of what it might cost. Senator Bruce?
I was just going to say that the fiscal note, I could see might take more than a day or two. And if so, we have that other week where this would have to go anyway, maybe to appropriation.
Well, once we put in the language about the
so if
there people getting paid for serving on the committee, then it has to go to appropriation.
And so I was going to say if there is out of Friday's testimony with Department of Mental Health and that designated agency, if there was some change that needed to be made after we voted it out of committee, we'd have another week to potentially do
Yeah.
that.
So
Okay.
is that right, Senator Sears,
Um,
just by adding the boilerplate regarding payment of per diems and such, that's enough to get it to appropriate?
Yes.
Yes,
Okay, great.
I actually raised that yesterday, so the chair of the appropriations committee is aware of it. I actually raised it. I think it was an oversight on our part last year and 2 years ago and this year in introducing the bill that we'll always pay people who, like Kelly Carroll, were a member of the group, that she should get paid per diem plus reimbursement for expenses traveling. It's not like,
Right.
I think it's $50 a day.
Right. And but this, and the separate question for Stephanie and JFO is also the
What, is there an impact on Vermont legal aid or other attorneys?
yeah, I feel like, as Jack was saying, I feel like that rings a bell that we had asked them something similar last year, or well, during the break, I searched my database and my emails to see if I could find something from JFO from last year. I couldn't find anything, but maybe it was before that. I can't recall.
I also searched and couldn't find it.
Okay.
Jack, you're muted, I think.
Jack, go ahead.
You're still muted, Jack.
I think his mic is probably just
Nope.
turned off instead of being muted.
Yeah. I do have, don't mean to interrupt, but I do have a memo from Jack McCullough from last year.
Oh, my God.
Yeah, I do too, but I don't have
It said,
numbers on it.
the pertinent part is, in addition, it is important to point out Vermont Legal Aid does not at the present have the resources to take on this additional caseload. We would anticipate that in the lead up to the effective date of this section, we would enter into a new or amended contract with the state to obtain additional funding for these new cases. So
Right.
that was February 12th, 2020.
Jack, we don't need your testimony because Alice has has all of your words.
Surprisingly, I have this file.
It wasn't in the vault, huh?
I actually had, it wasn't in the vault. I took it home on March 13th. There were a couple of them that I did.
Wow.
Taken home.
I took mine home too, and I have the same one, but it doesn't, I was looking to see if it had any numbers in it. I actually have my whole report that I gave on the floor last year.
Uh-huh.
Okay. Anything else on this bill? All right. Thank you all very much. We'll now move on to Eric. You're hanging in there. We have, who did S7? Is that Bryn?
It's Brand, yeah,
Oh, okay.
but I can hang around till she gets here.
And S30, you will have a rewrite of that for us for tomorrow.
Yeah, that's
You
ready
have
to go
time
whenever.
tomorrow morning?
Yep. And I
You
can,
have time tomorrow morning if we schedule you in after we do S3 at 8:45. Because you'll
Yes,
be
that's
here
fine.
anyway for that.
right.
Dick,
What?
Dick, may I ask, Dick, I'm sorry, it's Mary Morrissey. Are we done with S3 at this point?
Yes.
Mary Morrissey.
Yes, thank you so much. And thank you all for listening to Kelly's testimony.
Yes, thanks for bringing her.
You're welcome. Okay, thank you. Okay.
Senator Sears, on the S30, do you want me to go ahead and send that to you, or do you want to wait till tomorrow?
Well, I
hadn't seen
think
that
we
on-
could, it's up to Senator Baruth
I
and
think that
myself, so.
the changes were pretty minimal. So I wouldn't worry about sending it out to us in advance, but you mean to Senator Sears and I?
Yeah, or, yep, exactly. Or whether you want it posted today or just wait till we look at it tomorrow, whatever you think.
I
I
That's
don't
your
care.
call, Dick, whatever you prefer.
Well, let's post it today and people will see it. We need to allow in, Peggy, the folks who, that we had in on the last time we marked up the bill.
Which bill are you talking, we're still talking about S3?
No, we're talking about S30 right now.
Oh, I'm sorry. I was emailing Matt.
Picking up S30 right now?
No,
tomorrow.
tomorrow morning.
Dick,
I'm
I'm
dual
just,
tasking.
Yeah.
just checking. So if we have, during markup, if we have people in the Zoom room with us, they don't speak until we call on them, right?
That's correct.
Okay,
We're not taking testimony on the amendment tomorrow morning.
okay.
So,
Marking up and.
So
It's just like having them in the room. You might ask
understood.
for their input or not.
Yep, understood.
It's the only way under Zoom to get them involved in the room.
There's a peculiarity of Zoom that I don't know if there's a way to deal with it or not, but when you have people in the room and they choose to have their camera on, in the room, you have a discussion where we're all facing each other and they're on the outskirts. But in Zoom, Zoom picks who you're looking at. So it may be that you're looking at two members of the committee and two people who are just listening. So it seems like I wish that Zoom allowed you to put people in an order.
It does.
Does it?
It does. You can move your own people around. Like
Okay.
right now, I'm gonna move you and where Eric was. And now you're.
But it
where
doesn't
Eric
move them on
was.
mine.
It doesn't move anybody else, but you can just hold the picture. Now I'm gonna get rid of White and put Eric next to Ruth, put Benning next to Eric, and put White down in next to Peggy, who isn't on Zoom, and I don't have to look at her.
I
Um,
think Philip's point
And
though
Alice
is,
is right in the middle.
I think Philip has a good
People
point
probably
though.
who are in,
It's people who are, it's not us that are confused about it, but it's people who might be watching on YouTube.
Right.
And so they see this just mass of people and they might even be confused about who are the committee members who are doing the talking and the discussing here. Is
Right.
that person one of the committee members or not?
And if
well,
you have
we
two
can
sides,
ask people right now, David Scher and Judge Griffin don't have their videos running. So we can
Yeah.
ask them
Right.
not to have their video running until they're called.
I think that's great. That would
So, and
Solve the
Peggy doesn't have
Yeah.
hers video on either.
Yeah.
So that's one way of dealing with it.
yeah, I think that's the best way for sure.
Yeah. I find that in our committee, most people who, unless they're part of the discussion, when you're just having a discussion with lots of people, they do put their cameras off.
So, Eric, we will do like S3 from 8:45 till about 9:30, and then take up S30 at 9:30. I think that was right.
And where are we with S25? Is that coming up again? Cannabis bill?
Hopefully
We have a bunch of stuff. We're going to finish that up. We made some recommendations for amendments yesterday and Michelle is writing those up.
So they'll come to us.
We can get them to you tomorrow morning.
Yeah, that we sent Michelle was waiting for me to okay an email she sent with the final draft on, and what's happened is I've got over 100 emails came in this morning, and now I can't find email.
Go to search.
Michelle's
Yeah.
name.
Thanks. I was just gonna tell Michelle or Peggy to send her a note. Oh, memo, yeah, here it is. Thank you, that was a great idea. It's, has to do with S, 25, asking the appropriation of the Agriculture Committee to look at S-25.
Oh, yeah. And we, two members of AG are on government operations, so they were going to put pressure on the chair to take it up.
I can
Well.
very clearly imagine that situation.
And also Chris Pearson is the vice chair.
Yes. They don't. I told Bobby that he needed to deal with it because
Mhm,
it's confusing to the hemp. The hemp people also want to talk.
mhm.
Thought he conceded to do.
He did yesterday at
Chairs
Chair's meeting.
Yeah.
He said he would do it.
All right, thank you. So I guess, we're waiting. So we have S-25. We'll try to deal with that on Friday. Are your amendments ready, Senator White? Your committee's amendments?
Or wait, what?
Are they ready? If
When
we
do
were
you
to
wanna
take
deal-
up S-25 tomorrow,
Okay,
are your parts and our parts
we'll have them
um,
ready.
after we do S-30 and S-3?
Yeah, Michelle is writing them up right now, and we'll just do a final look at them this afternoon and
Okay, so we'll try to take care of those tomorrow and then Friday.
So on S30, Senator Sears, I've got the new draft on, which I'll send. On S3, if I'm understanding it right, that tomorrow is still in the markup stage. Is that right?
Yeah, we would hear from Judge Grierson and Matt Valerio, and then continue the markup. The draft that we've got in front of us, we had this morning, is what we'll
Right.
be working from.
I can send that to them if you like.
Well, it's on the web page too.
Oh, that's right. That's right.
Judge, are you here on this bill?
I think I'm here on, I think it's S70 we're going to take up at 11:45.
Yeah,
and
it is.
I was just
Yeah.
here to hear. I don't have anything to
Okay,
add.
so
other
we're
than-
we're talking about sending you, having you in tomorrow morning. We have a rewrite of S3 that Eric will send to you, and
All right.
you have comments on it. It's been posted on the website.
Okay. Yeah, Peggy reached
But
out to
we
me.
will go to. Yep. And then an issue has come up about S107, which is in Judiciary now, that we were discussing. And
if you want to start taking testimony on it now, but it really should have
No.
gone back to Gov Ops, because that's where it came from, and it only deals with law enforcement and public records. So those are our jurisdictions. It came from David Scher, the issue.
no, we've talked about this issue before. I think I'm inclined to, at 1 o'clock or whatever it is, whatever time we're meeting on the floor to, make a motion to move S107 that be relieved and that it be sent to government operations unless there's an objection.
Thanks.
We'll let you deal with it, Senator.
Well, we
and take
voted it
all the
out
heat
yesterday
for it.
because I thought it was sent to us. I mean, we
I don't know
developed
how
the
you did
bill.
that.
when I was writing down where they were sent, I thought I heard that it was sent to us. It must have been a different one. And since it was our bill to start with, we just voted it out.
Well, it was not your bill, it was your issue, and you discussed the issue. Then you created a bill, which you
Right.
then introduced. And when the bill got introduced, it got sent to judiciary because it
Right.
dealt with juvenile delinquency
Right.
and arrest records and other stuff. So I think I can understand why it was sent to us. You did tell us you were going to take testimony on it, and if we wanted to look at it, we could. And then it got introduced, and now I think the simplest thing for us to do is say, you got it.
Is there a place to look at it, Jeanette?
Sure, S-107.
The
Just
new
go
version,
online.
what you passed out.
It is S-107 is the bill, yeah.
Yeah, but your amendments.
No, that our work is
It's a
the
committee
bill.
bill.
Oh,
It's not a
okay.
committee bill because one person didn't want to be
Fine.
involved, so.
I
What
see.
happened was Senator White and all members of her committee, except for Senator Collmore, introduced a bill.
Yeah.
The
Yes.
bill, instead of going back to government operations to get voted out, ended up in judiciary because it looked
Yep.
like it was
Right.
Molly, Lieutenant Governor Gray and Secretary Bloomer decided to send it to judiciary.
Right,
Senator White would like us to get relieved of it and send it back to government operations so they can vote it out formally.
I'm with all that. I'm just wondering, where can I see it?
on any place, it's
Just type in
S-107.
S-107 on the
As revised.
legislative website.
Just
right there.
S-107, just type that in, S-107.
All right.
There's
Okay.
no changes to it because it is the bill that we produced.
It's probably on our website now under bills.
Okay.
Yes, that
And
too.
it's also just if you go to the homepage and type in S-107, it's there.
Got it.
All right.
Okay. No changes. Okay.
So much procedure.
Okay.
I'm thinking about Mark yesterday, talking about how he came
Yeah.
to love procedure.
Yeah. Came to love procedure. Don't we all? I gotta say, Zoom has one advantage, and that is I can open my windows and be in 56-degree weather here in Bennington on a sunny Wednesday, and may even have my meet outside for my Appropriations Committee meeting this afternoon. Maybe sunny enough out of it.
Woo.
Crazy.
But it's a beautiful day down here, and it is now 11:30, and so we're gonna take advantage of that and move to S7, which is a bill related to expungement. We've all worked on, and we've got a lot of people here waiting for us to take it up, and they all came a little bit early. We thank them for that. I gotta find my bill. So, I guess here we go. S7. So, Bryn, do you want to lead us off here?
Sure thing. So good morning, committee. For the record, Bryn Hare from Legislative Council. You do have a new draft of S7, which I'm happy to put on my screen if that's helpful for people.
Is that 1.2?
Yep.
Nope, it's draft 2.1.
Can you send it to me also, Bryn, and I'll
Sure.
post it?
Sure, I thought I did. Sorry about that.
No worries.
Okay, so Peggy, you should have that in a moment. And usually it's helpful for this committee if I share my screen. Is that right?
Yes.
Yep.
Okay. Okay. Can you see draft 2.1 S7?
Yep.
Can you blow it up a little bit?
Sure.
Oh, perfect.
Is that?
That's good. That's good.
Okay. All right, I'm just gonna try and move it. Can you still see it?
Yes.
Yep.
Okay, great. I've got so many screens here.
Oh,
Okay,
that's
so-
perfect.
Okay, great. So there's just a few changes to this version from draft, I think 1.2, which you looked at before town meeting week. So I'm gonna jump to those changes. And the first one is on page 9, I believe. And I'll just remind the committee, these were just the last few points that you were discussing with respect to this bill last week. So the change here, this is that provision that you looked at before that says that only the office that prosecuted the case can stipulate to a petition to seal or expunge that's filed prior to the date that the offense is eligible pursuant to the statute. And I've just added a little additional language here to clarify that this only applies if the person is petitioning to seal or expunge prior to the date that the offense is eligible as provided according to the statute. So I think there was some conversation still ongoing about that.
Yeah,
piece.
we're
Hopefully
not
that clears
seeing
that.
that change. Bryn, can you scroll up on your version?
We're only on page
We're
1.
only seeing,
Oh, really? Okay, let me
Yeah.
try.
there we go.
Now you can see
If
it?
a person petitions.
Yep.
Okay. All right, so the language in yellow is new, and it adds some additional clarifying language that provides that if it's this applies only if the person is petitioning prior to the date that the offense is eligible according to the statute.
By the way, that Peggy has posted the version on the website if people want to follow. The website.
Okay.
Go ahead, Bryn.
Okay.
Mhm.
So the next change is on the following page. And this is the new language that deals with the provision that the committee has been spending some time talking about where a person is subject to a probation term that is dependent on a condition of that probation that requires them to pay restitution. So this language comes from or originated from the Defender General's office, and I've just made a few changes to that proposed language. I don't think it's altered the spirit of the language at all, but it makes it clear what kind of circumstances we're talking about. So it provides that anyone who's convicted of a qualifying offense for which that person has to serve a probation term, a condition of which is that payment of restitution, is entitled to petition the court to seal or expunge that offense once their probation term is completed. And then the second sentence says that the petition has to request that the court, in the interest of justice, adjust the waiting period for the sealing or expungement as it's set out in the expungement statute. And then it directs the court to consider this request. And in considering adjusting the waiting period, the court has to consider the nature and circumstances of the offense, typical sentences for similar offenses, and the length of the sentence that was served by the petitioner in deciding whether to adjust the waiting period and any adjusted duration before the person is eligible for sealing or expungement.
Bryn,
Yes.
just a quick question about the first sentence. It says that they may apply on completion of the probation term. Is that including restitution?
So that my understanding is that would include restitution if the probation term is has as a condition of the probation require the defendant to pay restitution. So it doesn't explicitly say that, but I think it's implied by the fact that.
Yeah, I thought that one of the things, and Joe, correct me if I'm wrong on this, I thought one of the things we were discussing was that those people who had restitution as a condition that held them out of the sealing and expungement process for such a long time sometimes, as in the case of Erica Reddick. Is this in line with what you were hoping for, Joe?
Well, some people, and keep in mind, we're dealing with a limited number of individuals now, but some people have been given a probation sentence that has the limitation of until further order of the court. And one of their combined or conditions of probation is that they pay restitution. So when it takes an extremely long period of time to pay that restitution, maybe it's $5 a week or whatever the case may be on a $10,000 judgment, under that situation, they would still remain on probation until further order of the court. And I'm not sure that this language as written would take care of that kind of a situation.
Did we hear that they're not doing that anymore? And so it's
That's
mainly
correct.
people, it's mainly people who are, so maybe we need to put in something there about people who are currently in that situation.
Yeah, I would agree, because they are not doing that anymore. So we're talking about a finite group of individuals.
Right. How do we do that?
We toss it to ledge counsel.
Okay, so can I hear that once more? I was trying to adjust my
Okay,
my
so
blinds so I wasn't so to improve my picture. Go ahead.
there are some people out there who have been sentenced in a way that their probation term reads until further order of the court. You're on probation until further order of the court. So there's no finite term for them at that point. One of the conditions of probation that they have is to pay back restitution. If their restitution is an extremely small amount on a very large bill, that could mean they are on probation for many years, well beyond what anybody would normally be on for this particular situation. And they're only there because they're on this payment plan that's keeping them held up. The question is, how do you address those people and give them an offer of expungement if that open-ended term is still, they're laboring under that open-ended term? And I'm trying to read the language 4 and 5 times over as we speak, trying to figure out how to resolve that.
So is the idea for the person to be eligible prior to satisfying the condition of paying the restitution?
Well, that's, I guess, would be my hope. I'm not sure how you get there. And I think Judge Grierson had some concern about that. And I don't know how we reach a middle ground. Maybe Judge
I can't
Grierson.
remember his concern. Oh, there he is.
I'm here. Right now, in order for a person to be eligible for sealing or expungement, they have to have completed their sentence, i.e. they are no longer on probation. And they have to have paid restitution or completed their restitution. Because this involves just a very small number of individuals, I think, and I don't know the exact language, but in concept, I think you could say that if they've served a term of probation with payment of restitution as a condition of probation, once the restitution has been paid, the person could seek a discharge of, and assuming that's the only condition that's keeping them on probation at that time, once they have paid the restitution, they could seek a discharge. And if that discharge is granted, then the court could consider a request that begins on page 13, line 13. The person could then request that the court, in the interest of justice, shorten the waiting period for sealing or expungement. So I think you have to start with the discharge being granted.
But the problem is that they'll never pay off the restitution.
couldn't
So if
we
you're,
say, oops, sorry, Jeanette.
I'm sorry.
Couldn't we say, as we did with fees, when we didn't want the payment of fees to withhold certain candidates, we just said that the payment of fees wouldn't be a factor? Couldn't we say here that failure to complete payment of restitution will not in and of itself disqualify a candidate?
Yeah.
What I don't know, Senator, is on these old cases, and maybe Senator Benning may be familiar with it, or David Scher, if he's still on. When it was a condition of probation, I'm not sure that they entered into a so-called restitution order in addition to being on probation with a condition of paying restitution. So if you discharge them from probation, and that's the only condition that's out there, there's nothing to enforce at that point. In other words, there's no way to track the restitution. But if I remember the individual who came before the committee, I thought that that was a situation where she had paid the restitution and couldn't get off probation, and therefore, because it was till further order of the court, and therefore couldn't apply for sealing and expungement. I think it's more common to find that the person has paid the restitution, but they've got this outstanding probation until further order of the court, but I could be wrong. I think you're still going to want a discharge from probation and then couple that with a request to shorten the period waiting for sealing or expungement.
I think we need to do something about the people who are on a $5 a week payment or $5 a month or whatever it is, that just are going to be there forever and ever if they can't. Do we know if those people actually exist that haven't paid the restitution?
If you're asking me, I don't have a number on that. I don't know how many people would be affected by this.
Because I thought that was the issue, that they couldn't pay off the restitution.
And I could be wrong, but I thought it was the reverse, that they had paid restitution but couldn't get off probation.
Judge, is it your opinion that anybody who is subject to a restitution responsibility is going to avoid that restitution if they are no longer on probation? Because we have this restitution unit, it's now a civil enforcement process, and I'm trying to wrap my head around what happens if you did give them permission to get an expungement. Does that necessarily leave them no longer responsible to the restitution unit?
The problem is that when you, if you seal or expunge the underlying case, they're effectively, you've taken away the basis for the judgment that was entered. I think you'd need to talk with the restitution unit to really understand the implications of that. It's my understanding that from past testimony that they've provided, that it's, I know from a debt collection standpoint, if you eliminate the judgment, you've eliminated the ability to collect the debt. And so I think that's the problem with, that's why restitution right now under the statute has to be paid before.
But this still requires the payment of the restitution, right?
This does, but the question is, as I read this language now, and the question that's been raised by the committee is the person still on probation? And so I'm saying, if you couple this ability to request a shortened sealing or expungement record, I think it would certainly address the issues as I understood the individual that appeared before the committee. In other words, discharge him from probation and then allow the court to consider a shortened period for restitution. But this doesn't provide for discharge right now. And so they haven't completed their sentence, and therefore they're not eligible. The time period for eligibility for sealing and expungement hasn't occurred. You've got to eliminate that conviction. They've got to, or I'm sorry, you've got to, they have to have completed their sentence. Whatever word we're using, completed or executed, you know, they satisfied.
That, I think that's. Once they've satisfied the restitution.
Yeah, I think they're protected once they've satisfied it. The question is whether or not, if they're stuck on this $5 a week payment plan for 20 years to pay off whatever this massive bill was, they can never get their record expunged. And this may be something we can't solve. It may just be something that we have to leave, and I'm not sure what else to do about it at this stage.
I don't think there's much you can do until, unless you can go back to court and have the conditions changed. And didn't we do that in a different bill? In the probation bill, don't we allow for, in S-45, didn't we allow for somebody to go back to court to change conditions?
Yeah, that was at the midpoint review. There was.
Yeah,
opportunity for-
Yeah, we did.
So I think they could do that. They could say, you know, this $5 a month's keeping me on probation for the next 20 years. Is there a way we can resolve this and whatever? So,
Marshall Paul had that idea of to allow a judge to recalculate the term of probation and of the sentence after if the sentence was completed, and then just go with the restitution. I don't know.
Yep, this is the language that the Defender General's office submitted. I've just amended some of the wording a little bit, but I'll let Marshall weigh in as to whether he has any comments on that.
No, this is substantively the same proposal that we had made, and it was to address, not a situation of someone who is stuck paying a small amount every week for a long period of time.
Yeah.
This does not solve that problem. It wasn't intended to. This just deals with the problem of someone who had restitution as a condition of probation, and because of that, it took them a very long time to complete their probation, to complete their restitution. And this simply allows the court to, so for example, in Ms. Reddick's case, she was off probation and done paying restitution, but she still had a long time to wait before she could get an expungement. And this would allow a court to recalculate that waiting period because she was on probation for sort of an artificially long time. And that's all that this language was intended to address.
But Marshall, would you agree that they have to be discharged from probation in order to do that calculation first?
Yes, I mean, I think the intent of the language that I drafted was that they are off probation, because that if they have restitution as a term of probation, then the idea was, because I wasn't, in proposing this language, I wasn't trying to change anything substantive about how restitution is currently collected, or the criteria for collecting restitution, or even the criteria for getting a sealing or expungement.
Right.
So this wasn't meant to make it so that there was a way to get an expungement while you still owed restitution. It was just to deal with that, with Erica Reddick's problem.
Does this satisfy the committee to solve that problem? I think the other problem solved in S-45.
Yeah.
Yes.
Yeah, that explanation helped.
Yep.
Okay.
Yeah.
Moving right along, Brent.
So I did hear Judge Grierson say that we may need to change just this completion of the probation term to satisfy as the judgment for the offense, which would be make that language more in line with the rest of the requirements in the rest of the statute. Does that make sense to everybody?
Yep.
Okay. So the next change is just something that no longer appears in the bill. And if you remember there, you spent some time at the last hearing about the issue of the particular breakout waiting periods if a person was convicted of a subsequent offense.
Yep.
For certain qualifying offenses. And we've just removed all of that waiting period language and gone back to the version that was passed last year. Everybody remember that?
Yep.
I think it's actually on page 17. That language doesn't appear anymore. And those are all of the changes that are made in this version.
Bryn,
Yep.
that language that were removed, that was May Reed's language, that was 3 years?
Right. That was the proposal from legal aid, yes, to make different waiting periods for
Yeah.
certain offenses.
Okay,
Yes.
great.
And that is it. Those are the only 3 changes from the last draft.
Fantastic. I would say.
Yep.
Are there any further comments from anyone who's in the room? Okay, committee, any further comments on this? Now, we have to have a new draft number, or can somebody propose
So I can
that
just,
we amend?
yeah, oh, sorry. It will have a new draft.
It will have a
Okay.
new draft number.
Yes, it will be draft 3.1.
So I'll move that we amend S7 with, that we accept the amendments to S7 in draft 3.1.
Is there any further discussion? I do want to mention we have a letter of support on our webpage for S7 from Anthony Lamora. I probably pronounced the name, from the R Street Group in Washington, D.C. That Government Affairs Association is strong support of S7. And whoever reports this bill might want to read that article. It has a lot of information about the economic impact of expungement. So, Peggy, would you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes,
Senator Sears.
Yes.
So now I move that we report favorably S7 as amended with 3.1.
Senator White moves that we report favorably S7 as seen in, as amended by draft 3.1. Is there further discussion by anybody in the room? Anybody on the committee? Further comments? Hearing none. Peggy, would you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
yes.
Senator Sears.
Yes. All right. Who would like to report S7? Senator Baruth?
I'm
Senator
actually
Benning?
hoping to
Senator White?
report another bill.
Okay, well, hopefully you get a positive vote on that bill.
Well, I'm a cockeyed optimist.
Senator Benning normally reports expungement bills.
Yeah, that's good choice.
Is that a yes, Senator Benning?
It sounds like I'm entering into default, Peggy.
No, seriously, if somebody, I don't, I've reported quite a few bills and I am planning to work with Senator White to report S3 if we get a favorable vote, so.
Well, Bryn, can you get me a short blurb on the bill? Peggy, can you get me a list of the witnesses? And Bryn, when you get the new draft in, I have to send that off to John Bloomer for registering purposes.
Yep, I just sent it to the committee and I will get you a section by section.
Actually, it's a lot easier. This is one thing that's easier on Zoom is filing the reports, getting them up to the secretary's office.
I
You don't
find
have
it
to-
much more difficult because I don't have that piece of paper. And so I forget to
Oh,
send it. When I have the
Oh,
piece of
okay.
paper,
well,
Peggy
Peggy sends us the note and reminds us what to do, which
yeah, I know. Even then I forget.
solved the problem for me. Well, Senator White. Oh, gosh. I hope you don't lose S107.
No, I already sent that one up.
Thank you very much. Is there any further discussion on any issues? If not, I suggest this has been a really productive meeting. And I wanted to emphasize that I take responsibility for not having DMH aware of the amendment this morning. The S7.